Good evening. Tonight is Wednesday, 9 o'clock. My name is Alena Shautsova. I am an attorney from Brooklyn, New York, and we continue our legally speaking seminars. Today's one is dedicated to mediation. Mediation is the way to resolve an employment controversy. Mediation is an alternative dispute resolution. It is an alternative to resolving a case in court. Basically, mediation is an agreed upon by all the parties process that helps the parties to come to a resolution of an employment discrimination case. Mediation can be used in other types of cases as well, but for the purposes of our discussions, we're focusing on employment discrimination cases. Usually, a mediation is offered by one of the parties after an employee complains about discrimination. It can be offered at different levels. For example, it can be offered by an employer prior to an employee taking his or her controversy outside of the employer frame, meaning that it's before the employee is going to EOC or before the employee is going to court. It can be offered during the EOC process. Currently, it's very popular by EOC to offer mediation as the alternative to going to court or to wait for the investigation to be completed. Or an employee can be, mediation can also be offered, or parties can agree for a mediation process after the case was filed in court already. What is the benefits of mediation, and what the process of mediation would look like? Well, basically the process of mediation is such. Parties would agree, first of all, on a mediator. A mediator is a neutral party, usually somebody with a lot of experience, specifically in employment discrimination cases. You would like to choose somebody who is familiar with the current laws and the ways the case would be decided in court if the case will proceed in court. So parties usually first agree on a mediator, and then they agree on the date. Date and time. On the date and time, both parties come with their attorneys, and in case of an employer, and an employer representative with authority to make decisions. Mediation sometimes may take the whole day. It may take several hours, so it may take several days. Very often, a mediator usually would like to start with a joint session, a short session during which parties introduce each other and exchange the primarily points of view on the issue, and then the parties go to separate rooms. So there is no judge, there are no witnesses. The evidence that can be offered usually in the form of different documents, and the best one of the benefits of mediation is that it is speedy and it's private. There is no public exposure. A person who agrees to go through the mediation does not need to worry that his or her case will become public and will be searchable online. So this is one of the pros of the mediation. Another very important benefit of mediation is that it's relatively cheap. The process in federal court, where employment discrimination cases are usually filed, may take years, and the parties, both parties, plaintiff and defendants, will have to spend substantial resources in connection with discovery. Mediation in this regard is cheap. By the way, there are different types of mediation. Some of the mediation programs are free, and the person does not need to worry about the costs. Other mediation programs are the parties use a private mediator, and there are costs of mediation, of course, but the benefits of mediation and the opportunity to resolve the controversy relatively fast is much more appealing than taking the case to court and waiting for years without knowing the result of the court proceedings. So, as I mentioned before, mediation is good because it's private. Mediation is good because it's relatively cheap and because it's fast. Another very important benefit of mediation is that it allows parties to see where they stand. Very often an employee feels that all they want is just to be heard and somebody to hear their voice and really what happened to them, why they believe that they were heard. And mediation in this regard is a perfect venue for that, because an employer will have to listen at the mediation and will have to at least during the negotiations somehow respond to the employee's points. Let's compare mediation to, let's say, arbitration. I prefer mediation because it's also less formal proceedings. There are other ways of alternative dispute resolutions except for the court proceedings. For example, in arbitration. However, in arbitration is a more formal process. There are rules of arbitration. There are rules of evidence, and many arbitrators, they have their own rules. The mediation is purely voluntarily process. The parties are not forced to agree to any other party's proposal, and the mediator, as a person, cannot make a decision that would obligate the parties to follow it. There is no binding element of the decision of the resolution of the mediation unless the both parties would agree to settle the case. Arbitration is different. Arbitration is more similar in this aspect to the court proceedings, because an arbitrator will rule in a case, and arbitrator's decision will have force of the court decision. That is why I personally prefer mediation, because it allows both parties to be free from the stress of the obligatory decision, and both parties have, they don't have to comply with the rules of evidence, they don't have to comply with other rules, and they don't have to bring witnesses. Of course, each party would like to bring as much evidence as possible to try to convince the other party why they believe they have a case, or why they believe the case should be, will not succeed. So to clear the position, the ground. So those are probably the main benefits of mediation. Let's focus on the process itself. So basically, as I mentioned before, whenever an employee would like to resolve, an employer agrees to resolve the case with a mediation, the parties first will agree on a mediator. When the case is an EOC, the EOC provides a mediator. Sometimes it can be an intern, somebody who just started practicing employment law, or somebody who's trying to join the practice of employment law, or somebody who's just interning with the EOC. And very often it's a very experienced person who's been in employment law area for many years, and of course that makes the process to go easier. In case of a private mediation, there are organizations that an employer or employee may look into or may turn to in order to search for a mediator. There are also court-appointed mediators, so court-administrated mediation programs. It's a confidential process, by the way, and anything and everything that will be said during the mediation will not be, the parties will not be able to disclose it outside the mediation room, which is also very, very important. So even if the mediation is in the courthouse, or a court-appointed mediator, court-appointed program, the parties participating in court-appointed mediation program, it is still confidential. Given that, of course, very often in courts, the judge who oversees the mediation will issue his or her proposal, which may not be confidential, but this is a different situation and different topic. Overall, I would suggest that the mediation is a very good and effective way of resolving controversy because it allows the parties to save time, money, it is confidential. It also takes the stress from an employee because testifying in a courtroom in front of the jury, in front of a judge, very often can be very stressful. And mediation is precisely the forum to avoid the stress and try to have it with as less resources as possible, including emotional resources as well. What would be the end of mediation? How the mediation would be resolved? Well, often the mediation is resolved in settlement because that's why the parties came to the mediation. Basically, the parties come to mediate the case if all they want to resolve the case. And the settlement usually would include some kind of a resolution that's acceptable to both parties, but not quite what they hoped for. And each party has to remember that. None of the participants will walk away out of the mediation room completely happy because a plaintiff will have to forgo a portion of what he or she would want to receive from employer. An employer would usually have to give a plaintiff more than they hoped for at the beginning. However, the value of settlement, the value of early settlement cannot be underestimated because it provides fast and quick compensation for an employee. It also relieves an employee from the stress of trial and litigation. As always, if you have questions regarding mediation, if you're thinking or if you were offered the mediation process, I will be happy to answer those questions. You can find me on the website workharassmentattorneys.com or at www.shautsova.com. Thank you very much, and it was a pleasure to talk to you this evening.